This audio file is the property of LA Law Institute and is protected by copyright law. Unauthorized use, reproduction, distribution, or dissemination of this file without the express permission of LA Law Institute is strictly prohibited and may result in legal action. Any infringement of LA Law Institute's rights will be pursued to the fullest extent of the law. This audio file contains terms and definitions for the subject contracts. Benefit of the bargain. The gain one would make if a contract is fulfilled by all parties as agreed. Bilateral contracts. A contract where there is an exchange of promises. Used as the modern default when unable to determine if the contract is unilateral or bilateral. Bona fide good faith purchaser. An innocent party who purchases property without notice of any other party's claim. Common law. All contracts are governed by the common law unless the subject matter is for goods. Contract. A promise or a set of promises that is enforceable by law. Requires mutual assent, consideration and lack of defense. Contract by conduct. Even though there has not been an expression, by language, creating a contract will be implied by the courts based on the conduct of the parties. Express contract. A contract that is formed either by words or in writing. Implied in fact contract. An implied in fact contract is created based on the conduct of the parties involved. One party bestowed a benefit and expected to be paid. The other party accepts the benefit.
E.g., eating a meal at a restaurant with the expectation that you will pay when finished.
Implied in-law contract. An implied in-law contract is also known as a co-see contract. A contract that is formed to prevent unjust enrichment by one of the parties.
E.g., you hire house painter to paint your home but he mistakenly paints neighbor's house who is aware and watching the painting.
Court of equity will enforce a contract claim on behalf of painter for quantum merit, reasonable value of services. Installment contracts. A contract where delivery of goods may occur in multiple shipments. Each may be accepted or rejected separately. Perfect tender rule does not apply. Output contract. A seller agrees to supply all that he can produce to the buyer for an agreed upon length of time. Will not fail for appearing illusory. Requirement contracts. A contract where the buyer promises to buy all his required goods from a specific seller who agrees to supply all that buyer requires. Does not fall into illusory category of contract types even though terms may be vague. Requirements for valid contract. 3 things are required for a valid contract. Mutual assent, consideration and lack of defenses to formation. Service contracts. Contracts for services, not goods, are governed by the common law.
Contracts for the sale of goods are governed by the Uniform Commercial Code, U.C.C.
Unilateral contracts. When a party requests performance which becomes an acceptance of the offer, a unilateral contract is formed. Breach. A breach is a failure to perform a duty that has become absolute. A duty becomes absolute when 1. Time for performance has arrived. 2. Conditions precedent have not been excused. 3. Duty to perform has not been discharged. Breach, UCC. All transactions require a perfect tender in that each term must be expressly met. Any failure of terms results in a breach. Breach of warranty. The difference between the goods as promised and as delivered. Cover. A non-breaching buyer may buy replacement goods to make up for seller's breach. Cure. When a seller ships non-conforming goods prior to time of performance and the buyer rejects them, the seller may notify the buyer that they will send new conforming goods in an effort to avoid a breach. Breach major. Non-breaching party does not receive benefit of the bargain and is excused from completing its own performance. May bring suit immediately. Breach minor. When the non-breaching party receives substantially what they bargained for. Must complete own performance but may sue for damages. Defendants may claim substantial performance has been performed. Warranties, UCC. All goods sold by a merchant include 3 warranties. 1. Warranty of Title II. Express warranty and 3. Implied warranties of A. Fitness for a particular use and B. Merchantability.
C.I.F. UCC cost.
Insurance. Freight. The seller does not assume any liability. Buyer pays for cost, insurance and freight until goods reach destination.
F. A. S. UCC free alongside.
The seller is liable for goods until the carrier accepts possession.
F. O. B. UCC free on board.
The seller is liable for goods until they are transferred to the carrier. Buyer then assumes risk. FOB destination, UCC free on board to the place of destination. The seller is liable for goods until they reach their destination as long as the buyer is aware of delivery. Four corners test. A test that uses the content within the four corners of the document itself to determine the meaning. Used with parole evidence rule. Integration/integrated in parole evidence. A contract is integrated if it can be shown that it is the complete and final expression of the parties. Parole evidence exceptions. Dam foil 1. Duress 2. Ambiguity 3. Mistake 3. Fraud 4. Oral condition precedent 5. Illegal subject matter 6. Lack of consideration. Parole evidence exceptions, UCC. Dam foil 1. Duress 2. Ambiguity 3. Mistake 3. Fraud 4. Oral condition precedent 5. Illegal subject matter 6. Lack of consideration. Statute of frauds, exception, UCC. In 4 cases, there is no writing requirement. 1. Specially made goods, 2. Admission in court, 3. Detrimental reliance or 4. Goods have been accepted by buyer. Statute of frauds, satisfied, UCC. When there is a sale of goods for $500 or more, it must be in writing but may be in the form of an email, a logo, a receipt or any mode that satisfies a sufficient memorandum requirement. Statute of frauds, UCC. Under the UCC, goods for the price of $500 or more must be in writing, signed by the party to be charged. Sufficient memo. Under the statute of frauds, a writing that identifies the party to be charged in a suit, which may be in the form of an email, a logo or other identifying mark. The terms of the contract must be included to satisfy the soft writing requirement. Unconscionability. A contract with an unfair clause at the time of creation. May be procedural, occurs during the bargaining process, or substantive, terms in the contract. Other types of unfair practices include adhesion contracts, warranty disclaimers, hidden small print in contract or limitations on liability. Unilateral mistake. A mistake made by one party to the contract. If the non-mistaken party knew or should have known of the mistake, then the contract will become voidable. A computational or transactional error is a mistake while an error in value is not. Duress. Either physical threat or undue influence is used to overcome the free will of a party to force them to enter into a contract. In some cases, economic duress is available. Contract may be voidable. Defenses to formation. 1. Statute of frauds. 2. Parole evidence 3. Absence of mutual assent, mutual or unilateral mistake, 4. Ambiguity 5. Misrepresentation/fraud 6. Lack of consideration 7. Illegal subject matter 8. Unconscionability 9. Incapacity, age/mental capacity. Consideration. Consideration is a bargain for an exchange and must include a legal detriment. Consideration must have mutuality. Consideration, exceptions. Exceptions to consideration are 1. Gifts/charitable organizations 2. Past consideration 3. Moral consideration 4. Nominal consideration 5. Pre-existing duty note. Under UCC, no new consideration is required for modification. Consideration, substitutes. Promissory estoppel, detrimental reliance. Illusory promise. A promise that has no binding obligation. Exceptions are requirement or output contracts and unilateral contracts. Legal detriment. A legal detriment is refraining from doing something one is legally privileged to do or doing something one is not legally obligated to do. Adhesion contract. An unfair contract that favors the stronger of the parties in the bargaining process. A take it or leave it contract or one with unfair advantage or hidden language. Ambiguity. A term in a contract that may have 2 or more meanings which may defeat the requirement for mutual assent. If both parties are unsure of the term, the contract is void. If only one party was unaware of the ambiguity, that party's intention will hold and the contract will stand. Illegal contract. A contract that is void due to the illegality of the material. If subject matter becomes illegal after a contract was formed, it's called a party to a contract that is under age of majority, 18, may disavow a contract unless the contract is for necessities such as housing or food. In such cases, liability may be enforced through a quasi-contract. Integration clause. In parole evidence, a clause in the contract that states that the contract is fully integrated and is intended as the final and complete expression of the parties. Also called a merger clause or the Four Corners test. Under the UCC, all contracts are considered to be partially integrated. Lack of capacity. 1. Under the age of 18. 2. Insanity. 3. Intoxication. 4. Duress or coercion. Contracting is legal but voidable with any of these parties unless they ratify/reaffirm commitment to contract. Merger clause. A clause in a contract that states that the terms and conditions are designed to be the final and complete expression of the intent of the parties. A merger clause will make a contract fully integrated. Misrepresentation. A material misrepresentation done with scienter, intending to induce reliance and which plaintiff does justifiably rely, which causes damage. Contract is void. A tort crossover. Parole evidence. A rule of evidence that states any statements made prior to or contemporaneous with a contract cannot vary, add to or contradict the terms of the contract. Parole evidence, UCC. A rule of evidence that states any statements made prior to or contemporaneous with a contract cannot vary, add to or contradict the terms of the contract. Under the UCC, contracts are considered to be partially integrated unless expressly stated otherwise. Statute of frauds. The following contracts must be in writing: my legs, contracts in consideration of marriage, contracts that cannot be completed in 1 year from the date signed, land contracts for lease or sale, promise by an executor to pay for the debt of the estate, goods sold for $500 or more, UCC, surety agreement to pay for the default of another. Statute of frauds, exceptions to goods. There are 3 kinds of contracts that fall under the SOF UCC which do not require a writing. 1. Goods are accepted and paid for. 2. Goods are specially manufactured. Or 3. Admission in court. Statute of frauds, satisfied. To take a contract outside of the SOF, by plaintiffs, each type may be satisfied. Marriage equals sufficient memorandum, year-long equals full performance, land equals part performance, at least 2 of 1. Improvements, 2. Paying property taxes. Or 3. Possession, executor equals signed memo, goods equals payment or receipt, surety equals main purpose doctrine. Unconscionability. A contract with an unfair clause at the time of creation may be procedural, occurs during the bargaining process, or substantive, terms in the contract. Other types of unfair practices include adhesion contracts, warranty disclaimers, hidden small print in contract, or limitations on liability. Fraud or deceit. Fraud or misrepresentation which may occur in either 1. Inducement, an affirmative misrepresentation made during the formation of the contract with scienter, which caused justifiable reliance and damages. 2. Execution, a party's signature was forged on the document or the party was tricked into signing the document. 3. Active concealment, omission or nondisclosure. Damaged party may have the contract rescinded. Incapacity. A party may be legally or mentally incapable of entering into a contract. Incapacity may be due to under age 18, insane persons, intoxication or duress/coercion. However, ratification by the underage party, et al., may reaffirm desire to continue the contract. If incapacity is due to age, party will still be responsible for food, shelter or clothing costs. Mutual mistake. A contract will be voidable if both parties make a mutual mistake as to the basic assumption of a fact concerning the contract which destroys the basis of the bargain. The requirement for a meeting of the minds has not been satisfied. Advertisement. An invitation to negotiate/invitation to bid. Does not contain definite and certain terms which will cause the contract to fail. Course of dealings. When the terms or intent of a contract are unclear, the courts may look to previous transactions by the parties for clarification. Used with parole evidence under the UCC. Course of performance. During the course of a contract, if an ambiguity should arise, the court may look to how the ambiguity was settled earlier to determine the proper outcome. Acceptance. Under the common law mirror image rule, A matching unequivocal assent to the terms of the offer made in the same mode as offer. For a unilateral offer, only complete performance can be an acceptance. Acceptance, UCC. An acceptance may be in any manner that may objectively be construed as an intent to contract. Additionally, an acceptance may be made by an agreement to ship or actually shipping conforming goods. If non-conforming goods are delivered, there is a breach. However, the seller may offer a letter of accommodation with the non-conforming goods which will avoid the breach, and in which case the buyer does not have to accept. In a case where both parties are merchants and there is an acceptance accompanied by different or additional terms, which the offerer has reason to know about, the offerer will have 10 days to object or the terms become part of the contract. Battle of the Forms. A battle of the forms occurs when there are conflicting terms in a boilerplate contract for goods. The different terms are knocked out and gap fillers are used in their place. Counter-offer. A rejection of the original offer but at the same time a new offer on the same subject matter. The offerer and offeree switch places. Firm offer. A merchant may offer signed assurances that an option will remain open, for up to 3 months, without consideration. Formation, common law. A contract is formed when there is mutual assent, meeting of the minds, offer, acceptance, consideration and no defenses to formation. Formation, UCC. Under the UCC, a contract may be formed based on either a subjective or objective view to show the mutual assent, meeting of the minds. Parties and quantity are required. However, even if terms are missing, the UCC can use gap fillers as reasonable substitutes. Course of usage, course of dealing and usage of trade may also be used as guidelines. Gap fillers. Under the UCC, missing terms in a contract may be implied within reasonable standards except quantity. In contracts for goods using boilerplate, different terms are knocked out and replaced by gap fillers. Terms may be explained using course of dealing, course of performance or usage of trade. Goods. Movable and tangible goods which are identified at the time of formation of the contract. Gravamen of the injury. When a contract is for both goods and services and is undeterminable which is predominant, the court will look to the breach to determine which law is governing. Indefiniteness. When the terms of a common law contract are indefinite, the contract may fail. However, under the UCC, gap fillers may be used to supplement. Indirect revocation. If an offeree receives notice from a reliable third party that the offer has been revoked, it will be held that the offer is no longer available. Knockout rule. The knockout rule is used when UCC contracts are made with boilerplate and different terms are knocked out and replaced with gap fillers. Lapse of time. The offeree must accept within a reasonable time or within the time stated in the offer. Mailbox rule. Under the mailbox rule, acceptance of an offer is effective upon dispatch. Rejections are effective upon receipt. Meeting of the minds. A subjective test that establishes that the parties to the contract had preliminary negotiations which resulted in a valid offer and a valid acceptance. Merchant. 1 who 1. Regularly deals in goods of the kind sold, or 2. Who otherwise by his occupation holds himself out as having special skill or knowledge of the goods sold, or 3. By his intermediary who claims to have special skills or knowledge of the goods sold. Note, merchants are always held to a higher degree of good faith. Mirror image rule. Under common law, an acceptance must match the terms of the offer, otherwise it is a rejection and a counteroffer. Mutual assent. An agreement between parties who are negotiating proposed terms of a contract. During this subjective meeting of the minds, an offer is made and an acceptance is given. Non-conforming goods. Goods that are supplied which are not exactly as ordered. Objective theory of contracts. Based on a reasonable person test, if the outward manifestations of the parties would appear that they intended to enter into a contract will be implied by the courts. Offer. An outward manifestation of present contractual intent, an intent to be bound, complete with certain and definite terms which is communicated to the offeree. Q-tips quantity, time of performance, identity of parties, price and subject matter. Under the UCC only quantity needs to be present. Gap fillers may be used for all other missing terms. Offer UCC. Under the UCC, only the quantity in a goods contract needs to be present. If the contract is for requirements or outputs, then no quantity is required. Gap fillers will supply missing terms. Option/option contract. Under common law, an assurance supported by consideration that an offer will remain open for a specified time. An option is considered an additional contract. Predominant factor test. When a contract consists of both goods and services, this test is used to weigh which law, CLV,
U, C, C, will govern.
In a case where it's 50-50, typically the courts will use the UCC since it is more liberal. In other courts, they may rule that the common law governs the service portion and the
C, C, governs the goods.
Preliminary negotiations. When parties begin to talk about the subject of a potential contract but there is no clear intent to enter in an actual contract. There has been no mutual assent or meeting of the minds at this point. Ratification. A party in a voidable contract, infancy, insanity, intoxication, reaffirms their promise to perform without requiring new consideration. Rejection by offeree. The offeree may reject by either making a counter-offer or an express rejection. Revocation by offerer. The offerer may revoke the offer except under 4 conditions. 1. An option has been paid. 2. If the offerer is a merchant and made a firm offer, or 3. Offeree has detrimentally relied on the offer, or 4. In a unilateral contract, offeree has begun performance. Termination by law. An offer can be terminated by law under 4 circumstances. 1. Lapse of time. 2. Death or destruction of subject matter. 3. Supervening illegality, or 4. Death or insanity of either party. Termination by offerer. An offer may be revoked by an offerer who is the master of his offer except in 4 instances. 1. An option has been paid. 2. Offerer is a merchant and has offered a firm offer. 3. The offeree detrimentally relied on offer, or 4. In a unilateral contract where offeree has begun performance. Termination by parties. Either of the parties to a contract may terminate the contract. The offer may revoke the offer in most circumstances, or the offeree may reject the offer either directly, via a counter-offer, or letting the offer acceptance period lapse. See termination by offerer for restrictions on revocations. Terms. Terms, but be definite and certain. They must include Q-tips, quantity, time for performance, identity of parties, price and subject matter. If terms are missing, the contract may fail due to ambiguity or indefiniteness. Terms, UCC. The only required term is the quantity. Gap fillers can be used to fill in missing terms. In order to establish terms based on relationship between parties, course of dealing, course of performance or trade usage may also be used.
UCC.
The Uniform Commercial Code was created to govern the sale of goods. Void contract. A contract which was never enforceable and therefore never valid. Illegal contracts and contracts subject to the statute of frauds. Voidable. A contract that may be voidable by one or both of the parties. Factors may include mistake, fraud, unconscionability, duress, infancy, intoxication or insanity. Condition. An act or event, other than a lapse of time, which either creates or extinguishes a duty to perform. May be express or implied. Implied are either implied in fact or implied in law. Condition, excused. Certain actions may cause a condition to be excused. 1. Prevention. 2. Waiver. 3. Anticipatory repudiation. 4. Breach. 5. Substantial performance. 6. Installment contract. 7. Voluntary disablement. 8. Estoppel. Condition, express. A condition that is stated in the contract and must be strictly adhered to, which the court will enforce. Substantial performance will not suffice. Condition concurrent. Acts or events from all parties must occur at the same time. Condition precedent. An act or event that must happen before performance from the other party comes due. Most typical kind of condition. Condition subsequent. After performance becomes absolute, an act or event that serves to extinguish or cut off the performance. Constructive condition. A condition that is not stated in the contract, implied, but that the courts will impose to make sure parties get what they have bargained for. Express condition. A condition that appears in the contract which the courts will strictly enforce. Implied condition. A type of condition that may be implied in fact or in law. Implied in law are called constructive conditions and may be concurrent, subsequent or precedent. Accord and satisfaction. In a good faith dispute, an accord is an agreement for a different promise, and the satisfaction is the performance of that promise. Available only under the UCC. Economic or commercial impracticability. An unforeseen event which makes performance financially unfeasible. Slight variations in market price or value won't suffice. Frustration of purpose. An unforeseen event destroys the value of a contract which allows the condition to be discharged. Performance is still objectively possible. An unforeseen event destroys the value of a contract which allows the condition to be discharged. Performance is still objectively possible. Modification. An agreement between the parties to change the terms of a contract. Under common law, consideration must be present. Under UCC, no consideration is required. SOF applies. Release. A written statement accompanied by consideration which discharges a party to a contract with an agreement not to bring suit. Rescission. Rescission is a way for one party to get out of a contract for such issues as fraud or mistake in both law and equity. A bilateral rescission requires the mistake or misrepresentation to be by both parties. The rescission is a separate contract, with the legal detriment being the agreement not to bring suit, combined with restitution to keep one party from unjust enrichment. Risk of loss. UCC risk of loss on delivery of goods is placed on party in best position to insure against the loss. Substitute contract. If the parties agree to enter into a second contract, the first contract is discharged immediately in place of the substituted contract. Supervening illegality. When the subject matter of a contract becomes illegal after formation, the contract is unenforceable. Anticipatory breach. Expressing an unequivocal intent to refuse to perform contractual duty. Non-breaching party may bring suit immediately, wait till performance is due to bring suit, or treat the contract as discharged. AKA anticipatory repudiation. Anticipatory repudiation. Expressing an unequivocal intent to refuse to perform contractual duty. Non-breaching party may bring suit immediately, wait till performance is due to bring suit, or treat the contract as discharged. AKA anticipatory breach. Defendant may rescind intent to breach before performance is due. Anticipatory repudiation. UCC expressing an unequivocal intent to refuse to perform contractual duty. Non-breaching party may bring suit immediately, wait till performance is due to bring suit, or treat the contract as discharged. Defendant may rescind intent to breach before performance is due. Non-breaching party may demand assurances that defendant intends to perform. AKA anticipatory breach. Equitable estoppel. A party to a contract offers a false statement of fact to induce reliance, and plaintiff justifiably relies on the information resulting in damages. Differs from promissory estoppel in that fact versus promise is at issue. Impossibility. When the performance of a condition has become objectively impossible to perform due to an unexpected event, the condition may be excused or discharged. Prevention. Prevention of performance doctrine. A party shall not interfere with another party's performance. Substantial performance. Substantial performance is a measure of completion of performance under a constructive, implied, condition. A minor breach may result in a substantial performance claim depending on how much was accomplished. Only in use for common law, as UCC requires perfect tender. 1. Breach was not willful. 2. Non-breaching parties got substantially what they asked for. 3. Non-payment would be an undue hardship on the plaintiff. 4. Defendant can be reimbursed for what he did not get. Voluntary disablement. Also known as prospective inability or unwillingness to perform. One party may have reasonable doubt that the other party may be unable or unwilling to perform when performance is due. Party may request assurances that performance will be completed and even suspend its own performance. Waiver of condition. A waiver is an oral agreement to modify the terms of an agreement. Conditions constructive/implied. A constructive or implied condition does not expressly appear in the contract but is required to further the contract. Conditions of cooperation or performance are implied in all contracts. Covenant. A covenant is a promise to do or to refrain from doing something. A failure to perform is a breach. Demand for assurances. When a seller, either through words or conduct, raises doubt as to their intention or ability to complete an upcoming performance, the buyer may suspend their own performance and demand reasonable assurances that the seller will perform when duty becomes absolute. Detrimental reliance. One party reasonably and detrimentally relies on the promise of another. Under the theory of promissory estoppel, the other party is estopped from backing out on their original promise. Discharging performance. The duty to perform can be discharged by 1. Perfect tender, UCC, 2. Full performance 3. Condition subsequent 4. Illegality 5. Rescission 6. Release 7. Substituted contract 8. Impossibility 9. Modification 10. Frustration of purpose 11. Impracticability 12. Novation 13. Statute of limitations. Divisible contract/divisibility. A contract may be divisible if performance may be divided into 2 or more parts, equally between all parties, with each successful unit of performance payable regardless of the status of subsequent units. The contract must have been created as a divisible contract during formation. Express warranty, UCC. A promise that a product will work or will work in a certain way. The promise may come in the form of an advertisement, sample, name, slogan, or any other expression of the product. Watch for statements of value versus opinion. Implied warranty of fitness for particular purpose. All goods sold by a merchant come with an implied warranty of fitness for a particular use. The buyer justifiably relies on the advice of the merchant, who is aware of the buyer requirements for their particular use/needs. May be revoked by the merchant if done prior to or at time of formation of purchase. Implied warranty of merchantability. All goods sold by a merchant come with an implied warranty of merchantability. Merchantability is being of fair and average quality for the kind of good. May be voided by the merchant if done prior to or at time of formation of purchase. Modification, UCC. A good faith modification does not require new consideration, however it still may fall under the statute of frauds if the final price is $500 or more. Perfect tender rule. Under the UCC, the delivery of goods must match the terms of the contract exactly or it will result in a breach. Performance. Performance becomes absolute when 1. All conditions precedent have occurred, 2. Conditions have not been excused or discharged, and 3. Time for performance is due. Failure to perform is a breach. Under common law, substantial performance is required. Under the UCC, perfect tender is required. Promise. An agreement or a covenant to do something or to refrain from doing something. A broken promise results in a breach. Promissory estoppel. When one party foreseeably relies on the promise of another, the party that creates the reliance may not later refuse to perform. A breach may result in expectancy damages. Under the second restatement, only reliance damages are available. May be used as a substitute for consideration. Differs from equitable estoppel in that fact versus promise is at issue. Equitable remedy. When there is no valid contact but services have been rendered by one party, the courts may allow an action to keep one party from unjust enrichment. May be an injunction, specific performance, or reformation. Injunction. A court order to either do something or to refrain from doing something. Failure to comply results in contempt of court. Quantum meruit. An equitable remedy that serves to award payment for services completed by a non-breaching party. Reformation. An equitable remedy when the courts will fix an error in an otherwise valid contract to make it fair or to represent the original intent of the parties. Specific performance. A remedy where one party is ordered by the court to perform under certain conditions. I'm doing fine, Mom and Dad. An adequate legal remedy available. Definite terms. Feasibility of the remedy. Mutuality of the remedy. Defenses, to SP are not available. Avoidable damages. The non-breaching party has a duty to mitigate damages or risk reduction of award. Compensatory damages. Designed to put non-breaching party in position as if breach did not happen. Includes 1. Expectation damages, benefit of the bargain, 2. Reliance, out of pocket, or 3. Consequential, special damages. Consequential damages. Same as special damages. Based on Hadley v. Baxendale. Damages award based on foreseeability of harm at the formation of the contract. Must be 1. Foreseeable, 2. Reasonably certain, 3. Unavoidable, and 4. Causal, caused by breaching party. Expectation damages. Non-breaching party receives benefit of bargain as if contract had been fully performed. General damages. Term for monetary award that is based on the breach of the contract and used to protect the benefit of the bargain. Legal remedy. Monetary damages awarded to non-breaching parties. Liquidated damages. An amount of damages named in the contract at formation. Must be a reasonable forecast of damages even though it is difficult to ascertain. If damages are excessive, they may be considered punitive and not awarded unless proven. Nominal damages. A token amount awarded in a contract suit. One party may be just looking for official ruling and award is only nominal or no actual damage sustained. Punitive damages. A sum awarded to a non-breaching party as a punishment but typically not used in contract law. Reliance damages. Out-of-pocket expenses spent prior to learning of the breach. Restitution. Return of investment/benefit to plaintiff to avoid unjust enrichment by breaching party. Special damages. Same as consequential damages. Based on Hadley v. Baxendale. Damages award based on foreseeability of harm at the formation of the contract. Must be 1. Foreseeable 2. Reasonably certain and 3. Unavoidable. Unjust enrichment. Unjust enrichment occurs when one party, does not have to be in a contract, gains an unfair benefit from the plaintiff. If there is no contract, quasi-contract relief may be available. Restitution may be granted as a legal remedy. Damages. Generic term to represent award to a non-breaching party in a contractual lawsuit. Usually monetary. May be used to express harm caused by breach of contractual duty. Incidental damages. Relates to sales of goods only. Money spent on transportation, storage, inspection, etc. may be recouped by a non-breaching party. Lost volume sales. When a buyer breaches a goods contract, the seller is able to resell the goods. However, the seller loses out on the specific sale and its profit. Quasi-contract. A quasi-contract is formed when a service has been rendered, which was not intended to be free, and recovery is enforced to keep one party from unjust enrichment. Remedies. May be either legal or equitable. They are damages, restitution or specific performance. Remedies, buyer after acceptance. 1. Sue for difference between warranted versus delivered, damaged. 2. Difference between warranted versus delivered, non-conforming. Remedies, buyer prior to acceptance. 1. Sue for specific performance. 2. Recover damages on prepaid. 3. Hold goods for security. 4. Cancel order. 5. Cover. Remedies, seller after acceptance. 1. Sue for return of goods. 2. Bring action for price plus damages. Remedies, seller prior to acceptance. 1. Cancel contract and don't complete delivery. 2. Sell goods and sue for lost profit. 3. Sell goods already in production. Statute of limitations. Once a breach has occurred, there is a 4-year limit on express contracts. Third-party beneficiaries, classes. Donee, as a gift, creditor, owed money, incidental, not named in contract, modernly, intended, done and creditor unintended, incidental. Third-party beneficiary. In a contract that benefits a third party, that third party will have standing to sue to enforce the contract. The party must be an intended, donee or creditor, beneficiary. Incidental beneficiaries do not have the right to bring suit. Assignment. In a contract, one party may assign their rights to a third party. The assignment must be communicated to the promisor to be effective. The assignee steps into the shoes of the assigner and receives benefit from promisor. Assignment, exceptions. A party to a contract may assign all their rights to a third party except for personal services contract or unless prohibited by law. Delegation. The transfer of duties under a contract. Non-delegable duties include services that are too personal or prohibited by contract or law. Novation. A novation occurs when an original party to a contract agrees to be replaced either through an assignment or delegation and gives up associated rights. Privity. Under the case of Lawrence v. Fox, an intended third-party beneficiary has the right to sue to enforce their rights under the contract. Vesting. Vesting means that a person's right to something is absolute. In contract law, A third party's right vests, becomes absolute, depending on their classification. They may be a creditor, donee, intended or incidental. Creditor and donee both vest when given notice and assent. Incidental beneficiaries have no contract rights. Once third parties' rights have vested, original contracting parties may not alter terms of the contract.